Welcome back to the Gavel. On the breakdown this week, the Policy and Legal Advocacy Center continues from where it left off last week on the constitution amendment bills currently before the National Assembly, focusing this time specifically on the legacy bills that failed in the 9th Assembly and have been reintroduced in the 10th Assembly. So here's the breakdown with Plac.
The recent Supreme Court judgment on local government financial autonomy is a welcome development for local government operations in Nigeria. Now, before the 10th Assembly, there is a bill to create for the composition, finances, functions, etc. of local government councils to be created by an act of the National Assembly rather than a law of the State House of Assembly, which is what the Constitution currently provides for. And the bill also proposes to make the Electoral Act the governing law for local government elections, rather than the State Independent Electoral Commission Acts of the respective states. The bill also seeks for a separate local government account to replace the current state joint local government account. Another bill is on diaspora voting, which featured in the 9th Assembly. Now, key issues about diaspora voting remain that the security of the processes and the systems can be questionable, and it is up to the government to be able to provide transparency into that process to gain the confidence of the people. There is also an argument that early voting has not even been achieved within Nigeria, let alone diaspora voting. Another bill is on timelines for hearing and concluding civil and criminal cases. Some sections of the Administration of Criminal Justice Act address the timelines for criminal trial, which to an extent help to expedite criminal justice. Now, for civil cases, we cannot say the same. These cases continue to drag on and on and on. However, in putting a timeline to conclude civil and criminal cases, it is pertinent to consider court processes, what will constitute or what may constitute miscarriage of justice, and the number of judicial officers available to the courts per time. Another bill is on Code of Conduct Tribunal. The bill seeks to establish the Code of Conduct Tribunal as a court under the judicial arm of government. Now, the main reason it appears would be to insulate it from interference by the executive. However, if this is to pass, there are other administrative issues that may come up. Another proposal before the National Assembly is on traditional institutions. Actually, there are several bills on this. One of them seeks to establish a national, state, and local government council of traditional rulers. Now, a similar bill seeks to establish a national council for traditional rulers to facilitate good governance by advising the federal government on security measures, serving as members of the National Security Council, assisting the federal government in developing statistical data of people, driving sensitization of federal government policies at state and local government levels, among others. Now, traditional rulers and institutions were very much revered in the past, and even today, in some parts of the country, they operate traditional courts, and their decisions are accepted by the parties in a dispute. However, there has been a lot of political interference by state governors who have now waded into the issue of succession in these institutions. This interference has watered down the respect and regard for traditional institutions. Some people believe that including traditional institutions in the Constitution and granting them established roles will strengthen these institutions. Another bill is on the timeline for presentation of treaties to the National Assembly by the executive. This is in Section 12 of the Constitution. The provisions of various treaties that have been ratified by Nigeria cannot be applicable in Nigerian courts because they have not been domesticated. A bill before the National Assembly seeks to stipulate ratified treaties be presented to the National Assembly by the executive not more than 180 days after they have been ratified. This is targeted to cure the disconnect between the executive and the National Assembly regarding treaties.